Pirate Nation says Nintendo may not be able to recoup legal expenses of the Palworld lawsuit even if they win. Japanese attorney. So first of all, let me say this right now. Pirate Nation is one of the biggest uh Palworld cocksuckers I've ever seen in my life. Like every single time something comes out, this guy makes some kind of wild claim or statement or ridiculous. This is a really good example of just how delusional Palworld fans actually are. We last night we went over the rejection of the Nintendo patent and exposed it as being nothing more than a nothing burger. But today, we have a lot of the people that pushed that story initially coming out and trying to damage control for Palworld's inevitable loss. So, Nintendo may not be able to recoup legal expenses of the Palworld lawsuit, even if it wins. That doesn't make any sense. You're telling me Nintendo doesn't have enough money to file a lawsuit. That doesn't make any sense. Like, oh, we're so poor we can't even afford to pay for the lawsuit. But let's see. Nintendo may not be able to recoup legal expenses of Power lawsuit even if it wins. Yeah, and of course he doesn't post a link. Let's see if it Yeah, he just posted the stupid. Okay, hang on. Let's see if we can find the article itself. Let's see. Here's the actual source that Pirate Nation did not link on his Twitter account. Nintendo may not be able to recoup legal expenses of Palworld lawsuit, even if it wins, Japanese attorney suggests. Japanese patent attorney Kiyoshi Kurihara shares new insights on the lawsuit between Nintendo and Palworld developer Pocket Pair. Wait a minute. This happened in June, and he's reporting on it now? Wait, that's 5 months ago. Okay. It's been almost 9 months since Nintendo and the Pokemon Company lodged a patent infringement lawsuit against Palworld developer Pocket Pair. The latest official update on the case came last month from Pocket Pair's side when the developer confirmed that the prolonged litigation was still ongoing and announced that it would reluctantly be changing some of its game mechanics as a direct result of the lawsuit. Again, this is something you don't hear them talk about a lot. The company's already admitted fault. But going off court documents shared by GameSpray, wait a minute, GameSpray. That was the same. Okay, that was the same company that did the recent claim that Nintendo getting the patent rejected was somehow going to fuck them over. Um, Japanese patent attorney Kyushi. Wait, wait a minute. Going off court documents shared by GameSpray, Japanese patent attorney Kiyoshi Kurihara recently shared some insights on how the case is looking at the moment. Wait a minute. So this person is commenting on this based on that Game Phrase article that we already debunked. Okay, we're gonna have to look at that too. According to Kurihara, Pocket Pair has been following a standard legal strategy to defend itself so far. This includes denying infringement, claiming invalidity of Nintendo's patent rights based on prior art found in existing games, arguing lack of novelty and lack of inventive step. He notes that while some past lawsuits, like the Nintendo versus Columbia infringement, saw Nintendo as an overwhelming advantageous position, the Palworld case feels much less one-sided by comparison. This time, it appears to be a typical patent infringement case where both parties are engaging in a rapid back and forth, pushing for invalidity, infringement, respectively. That seems like a cope. I don't understand why game journals are so desperate to pretend that Palworld has a leg to stand on. But interestingly, Kurihara also suggests that the scale of this lawsuit could potentially make it somewhat fruitless for Nintendo. To assert its claims against Palworld, Nintendo is employing lawyers from TMI Associates, one of Japan's top 5 law firms, which has multiple places across Japan, Singapore, Silicon Valley, London, etc., and specializes in intellectual property cases. On the other hand, Pocket Pair is also being represented by major international law firms, Nishimura and Asahi, with both parties enlisting high-profile legal teams. Kurihara comments, although it's a crude point to bring up, I can't help but think that Nintendo may not be able to recoup the legal costs even if they win. The exception would be if Nintendo were to increase their claim amount from the current 10 million. What? To recoup their legal costs, even if they win. Okay. So what he's saying is that it's more expensive for Nintendo to go after this company than it would. But that doesn't make any sense. Like they have to do it because they violated their patents. But anyway, meanwhile, although it had to compromise on game mechanics like throwing PAL spheres and gliding on PALs, Pocket Pair is still actively updating and putting out new content for Palworld. The game's next major update, Palworld's Tied to Terraria, is scheduled to come out in summer 2025. Okay, so it was just a clickbait terminology saying that like they wouldn't make their money back by saying that through the through the course proceedings, which is fine. They're not trying to make money off the lawsuit. They're trying to shut this plagiarized product down. Okay, so this is the claim from the Kiyoshi Kurahawa. The most detailed coverage of the Nintendo versus Palworld patent infringement lawsuit is from overseas media. Yeah, because the Japanese already know that Pocket Pair is fucked. So this is the thing you'll notice if you really start like going into Nintendo rumors or like weird conspiracies like this, you always just see like the same handful of sites like citing each other and backing each other up and propping up this idea that Power World's totally gonna win, guys, and they're gonna embarrass Nintendo and they're gonna be bigger than Pokemon, and that's just obviously not gonna happen. And yet it's just kind of the reoccurring code we've been seeing for a long time. So let's see. The most detailed coverage of the Nintendo versus Palworld patent infringement lawsuit is from overseas media. A patent infringement lawsuit between Nintendo and Palworld is currently underway. Palworld released a statement about this a while ago. See article. The company stated, "We are confident." Well, Palworld is not the company. Palworld is the product. Pocket Pair is the company. So this expert doesn't even know like what the product is and who produces it. The company stated, "We are confident that we have not infringed any of the plaintiffs' patents, and are continuing to take action. We also assert that all of the plaintiffs' patents are invalid." Yeah, all of them, and yeah, most of them have gone through, and the one that wasn't is going to be amended and resubmitted. Incidentally, the original text reads, "We have not infringed any patents," but the correct translation is, "We have not infringed any patent rights." Additionally, Palworld has decided to make some preventive changes to the game specifications in order to continue development. This is a standard procedure in patent infringement lawsuits. When have we ever seen this happen? The three-pronged approach is to deny infringement, assert patent invalidity, and avoid infringement by changing the design. Someone commented, "If you think it's invalid, then you don't need to change the specifications. But since this is a lawsuit, you should assert everything you can." Plaintiffs don't usually take an offensive approach like, "You changed the specifications because you didn't think it was invalid," right? Now, regarding specific judicial developments, once a judgment is handed down in Japan, some of the judgment text is made public on the court's website, as well as in case law databases and case collections, which are available for a fee. However, information about ongoing trials can only be viewed by visiting the court. Furthermore, only interested parties can make copies or even take photos with their smartphones. Therefore, detailed information is difficult to obtain unless the parties announce it. So basically, this is hard confirmation of something I've been thinking for a long time, is that like nobody knows what's going on with the lawsuit. Like you only really hear about it when people think or can present something that happens as some epic W for Power World. Like they try not to talk about it at all unless they like want to pretend that like Power World's winning and like beating Nintendo. But um this is in stark contrast to the United States, where all federal court records can essentially be accessed online for a fee through a system called Pacer. However, an overseas media outlet called Games Foray wrote a detailed article about this lawsuit. Apparently, they asked a Japanese lawyer to obtain the information. Wait, what? They asked a Japanese lawyer to obtain the information. If you want to follow the details of this lawsuit, this site is currently the best place to do so. It's particularly helpful because it quotes the claim chart. A claim chart is a tool used in the so-called satisfaction argument, which is used to dispute whether this suspected product, or in this case, Power World, infringes a patent. Since this article is long, I'll explain it in a separate article. According to this article, as stated above, the lawsuit denies infringement and asserts invalidity based on the lack of novelty and inventive state based on prior art, primarily existing games. In the Nintendo versus Calliope lawsuit, Nintendo's patent was so powerful that it seemed impossible to know what to do. However, this time it seems less one-sided. And like a typical patent infringement lawsuit, it looks like a heated back and forth will continue on both the invalidity and satisfaction theories. For example, according to another article on GameSpray, Palworld has released. So this guy isn't even looking into it himself. He's just citing GameSpray. Palworld has released a video of a character gliding while holding a PAL before the effective filing date of Nintendo's patent, which could be argued as evidence that Nintendo's patent lacks inventive step. Let's see. By the way, this article does not clarify whether Palworld actually asserted this in a lawsuit, and the fact that the behavior was revealed in a video does not necessarily negate novelty. By the way, as I learned from this article, Nintendo is using a fair number of lawyers from major law firms such as CMI, and Palworld is using a fair number of lawyers from major law firms such as Nishimura and Asahi. I made a mistake in the original draft and wrote the opposite. Sorry. What? Okay. So, considering that the amount of damages sought in this lawsuit is 10 million yen, I can't help but think that Nintendo might not even get a return on their investment, even if they win. But like, why can't like like they don't need to win. They just need to Now this video media outlet GameSpray appears to be run by a German, probably currently residing in Monaco, intellectual property consultant named Florian Muller. Muller previously ran a website, currently no longer being updated, called False Patents. While he does not appear to be a licensed lawyer or patent attorney, he is extremely knowledgeable about intellectual property and actively disseminates information. I also learned about the Apple versus Samsung, Google versus Oracle lawsuits from this website. Let's see. Okay. 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 So again, like as I said earlier, it's just clickbait. Like everything you see in regards to the Palworld lawsuit is just clickbait. Like none of it means anything. The idea that Nintendo could lose money on this lawsuit, even if they win, it's just a giant cope because they're not trying to get, to make money. They're trying to protect their interest. They're trying to protect their brand, right? That's way more important to them than like making more money from this irrelevant Chinese knockoff studio. So, with that being said, like everything we've been told about Palworld from like the mainstream YouTubers and game journos has been a lie, essentially. Like they're not winning, they're not doing well, they're not like easily stopping Nintendo. The patent getting thrown out doesn't mean anything. And now this, like, well, Nintendo might not win even if they win the lawsuit. It's just like, what? What a gigantic cope. It really needs to be called out for what it is. Like these people are just grifting.